everyone. Welcome to the webinar today. We are thrilled to have BarthCalderon LLP attorneys host this webinar. We have had so many registrations, and I know this is a very popular topic. Real estate risks and how to avoid them. We're going to be talking about asset protection, and we have the one and only Bradley Barth on the phone, who is the partner of the Orange County, California office of BarthCalderon LLP. Before I give you some more details about the webinar, I just want to point out that we do have a Q&A box on the right-hand side of your page. And Brad has told me that if you have questions during the webinar, throw them in there, and he'll stop and answer them and incorporate them into the presentation, which I love. So if you have any questions, go ahead and put it in there. The recording is going to be available to all of you tomorrow in exactly 24 hours. We'll provide you with this presentation and Brad's contact info as well, which is on the screen right now. And so just a little bit about Brad. I found him because he actually does very frequent speaking engagements about this topic, and we hadn't covered it before. He is the supervising attorney of the firm's transactional and estate planning department that encompasses business formations, transactional matters, estate planning, domestic and offshore asset protection, probate, trust administration, tax, and real estate law. So all that good stuff, and also he's a certified wealth preservation planner on top of that, and a certified asset protection planner as well. He's been a professor teaching property estates and probate at a paralegal college, and he's a frequent lecturer to professional groups about estate planning and business succession planning and asset protection planning. He knows a lot about especially what landlords and property management companies should be doing here to protect their assets. And he does have a BA degree from Cal State University Fullerton and a JD degree with honors from Western State University College of Law in Fullerton, California. So with that being said, I'm going to pass this along over to Bradley Barth. Thank you so much for doing this webinar. We're very excited to have you on the call.
Great, thank you very much. And I always appreciate the opportunity to speak to real estate owners. And I always like to first start off by making a comment specifically about people who own real estate, because it's very much, I would say it's unlike any other type of asset that a lot of people invest in. And I just make a very simple analogy that many people who have, let's say, $1 million, and they put that $1 million and they stick it in a bank and purchase a mutual fund, or they buy a bond. I ask the question, I say, well, what's the likelihood of that $1 million bond suing you? And then the answer typically is, well, very little to none. And then I say, well, you take that same $1 million and you put it into a rental property and you have a tenant in there. And I say, well, what's the likelihood of that $1 million suing you? They say, well, it's very likely. It's also depending upon the jurisdictions, like here in California, where we have a very tenant-friendly environment. So when I have clients that have real estate as part of their overall portfolio, I always tell them that it's a great investment tool because you get appreciation, you get income, you get tax benefits, but you also have to appreciate that there are risks associated with this type of asset, unlike investing in a bond or a mutual fund. So I think I aptly titled this talk, Real Estate Risks and How to Avoid Them. And I also just want to make one additional comment as to how this topic kind of fits in, and the topic in a more general sense being that of asset protection. I believe I was in it with my bio. You could see that I do a lot more than just the asset protection. I do a lot of estate planning, administration. There are also some tax matters in there. But I want you to understand that for most of our clients, that there are the 5 key areas of a comprehensive financial plan. And that's insurance planning, dealing with typically life insurance and disability insurance. You have investment planning, you have income tax planning, you have retirement planning, and you have estate planning. I call that the 5 key areas of a comprehensive financial plan. And what I would say that there's one element that's missing. And because if you look at what these other 5 areas do, you look at like your investment planning. You want to have your portfolio go from maybe 5% to 7 or 8%, or you want to minimize some of your tax your tax liability. So you basically drop a couple of percentage points in your tax outflows. Or you're doing some estate planning, you're trying to minimize or transfer some assets during lifetime to avoid some estate taxes. But if you were to get into a lawsuit, we're not talking about single-digit differentials in your overall financial portfolio. You're talking about a loss of 40%. 60%, and in many cases for our clients, in the worst scenario, is 100% via bankruptcy. So I always say that asset protection really is that sixth element of a comprehensive financial plan. So I think it's important that as part of your overall your investment portfolio, you're using real estate, always bear in mind that you have a risk component and you have to take advantage of that sixth element of a comprehensive financial plan. So that's what this talk is geared towards, specifically on real estate. Of course, you can also, by analogy, expand this onto other areas, which I'm sure I'll get to through the course of the conversation. But this talk is going to be specifically geared towards real estate. So just from an agenda and housekeeping, I believe we're going to go about 45 minutes. That will take us to about 11:45-ish, and then we'll open it up to about 15 minutes of Q&A. And by all means, the moderator can interject with questions at any point in time. I gave her that invitation because it makes it more interesting to me as a speaker, and I'm sure if somebody has a question, many of you have the same question. So what is asset protection and why it's necessary for real estate assets? I think I kind of already mentioned that. Common forms of property ownership. I think this is very important to understand that there are different ways of holding title to real estate, especially if you own it individually, if you're married, if you're owning it with a third party that's not a spouse, maybe a parent, maybe a child, or maybe a business partner. And I'm going to answer the question that we get a lot of pushback saying, Brad, we don't need any kind of asset protection. My CPA just told me to go buy some more property and casualty insurance. So I'm going to address that question as why simply increasing your liability insurance policy is not an asset protection plan. And then, of course, we'll talk about the basic tools, and the basic tools, I'm sure, would be no surprise to anyone here on the call, is the use of LLCs and or trusts to hold property. And then, since we are talking about property, we're not just talking about rentals, we need to talk about people's residence as well. And residences are different than other forms of investment assets simply because they are classified as residential property as opposed to investment property, and they enjoy a different tax classification, but yet it's one of our most intimate of assets, and we want to make sure that we have some protections around that. And for those of us here in California that are on the call, we'll talk about the California Homestead Exemption. And just one of the benefits of me being a national speaker is I do get to go to different states around the country and take a look and see how those states' governments respect the homesteads of their citizens and how they have more inherent protections, where we here in California a little bit on the light side. So we have to deal with how do we protect our residents from the claims of our creditors as well. And at the conclusion, as the presentation, as the moderator already had mentioned, that there will be an attendee sheet. So if anyone does want to have a complimentary discussion with me, 1 hour, it will be available to you. We always present that because whenever I give these talks, I always get feedback saying that this is like drinking from a fire hose. It's a lot of information in a short period of time, and I totally appreciate that. I never really know who's in the listening audience. So I try to give you as much of a broad spectrum of the tools and techniques that we use, hoping that if something will be relevant for everybody. And so for those areas that you want to drill down more specifically, that 1 hour of free time is really time for you and I to talk specifically about your circumstances. So please, at the end, take advantage of that. It's a free hour of time. So let's kind of just go back to what I call a definition of asset protection. And I think what I have up here is pretty straightforward. Asset protection is simply the process of employing legal concepts to ensure your assets aren't unjustly taken. So what does that mean? Basically, you have assets, we have various forms of liabilities, we have tenants, we have car accidents, we have business-based liabilities, we have professional negligence, malpractice issues, we have things that our kids do, we have things that our spouses do. So we have sources of liabilities, and we also have assets. So we're going to look to various forms of insurances and various forms of structures to simply just separate those assets from liabilities. And then this is my definition I have highlighted here in red, because to me this is truly what asset protection is. It's not just separating assets from liabilities, but it's putting barriers between assets and liabilities, which then results in greater leverage to negotiate a fast and favorable settlement with your creditors. That's what asset protection is. It's leverage. Because when it comes to litigation, there's two phases of litigation. And again, this is very important to understand where we fit in the litigation game. That you have what's called the liability phase, and then you have what's called the collection phase. So the liability phase is, hey, did you do it? Did you run the red light? Were you negligent in your tenant? Was there an electrocution? What was the cause of the fire? There's simply a liability phase. Your assets really are not at issue at that point in time. The question of fact is, did you run the red light? No one's asking you what the value of your house is. No one's asking you for a financial statement. The question is, did you run the red light? Now, if you did run the red light, now you are a judgment debtor. There was a judgment against you because you were found liable. Now that you're a judgment debtor, what assets do you have that we can take away to satisfy the claims of the judgment creditor? This is where asset protection comes in. It's on the collection phase, not on the liability phase. And so that's why I say that it gives you greater leverage to negotiate a fast and favorable settlement with your creditors, because when you are found liable, you now have to collect on those. And if the more difficult, the harder a plaintiff's attorney or harder that a creditor has to work to try to satisfy the judgment, to foreclose on those assets, the more difficult you make it, not impossible, but the more difficult you make it, the more likely you are to enter into a faster and more favorable settlement with the planning than you would have been without the planning. You can think of it as not being low-hanging fruit. It's not that they can't grab the apple on top of the tree. You just don't want to make it easy for them as being the apple on the bottom of the tree. So the asset protection tools that we use simply just make you not low-hanging fruit. So it's, again, it gives you greater leverage to negotiate a fast and favorable settlement. What it doesn't say is asset protection is you put your stuff behind some wall and then you just throw care to the wind and you never pay out on the claim. That's not at all what it is. It's basically a giant negotiating and settlement tool. I want to make sure that's important, because I've been mystified, I think, out there in the marketplace. So unique to real estate, and I've dealt with every one of these things on the, and by the way, I've been in practice for 22 years now. So in 22 years, you can imagine I've seen quite a lot of real estate-based liabilities, and every one of them is highlighted here on the screen, from the slip and fall. I've had fires resulting in deaths in fires. I've had habitability issues. I've had lead paint and other hazardous and wastes on the property, electrocutions, and we've had dog bites. We've had them all. And every single one of those pose unique risks. And the difficulty is that not every insurance policy is going to cover all of these, and we're going to get to that in a few minutes. And so, like I said, unlike taking your $1 million and putting it in a mutual fund or putting it into a bond or putting it into a REIT, you're not going to have the dog bite problem. You're not going to have the habitability problem, because that's been, you didn't absorb that. But as a property owner, you have certain duties to your tenants, and then you have those what are called landlord, tenant, and habitability issues, all of which are represented here on this one slide. So not only do we have liabilities of a property we own, I want to also just take a quick moment to speak about ways of people may own property with more than one person. And this could be spouses, parents, it could be kids. And what I see often a lot is property held in joint tenancy. And I just want to address a couple things on joint tenancy, because I see this a lot, and I don't think people truly appreciate, one, its asset protection consequence, or two, its it's estate planning consequence. And so my experience has been, and I've even done this as a test to myself when I purchased property, and I would have the escrow person or the notary person come to my home to sign all the paperwork, and they would ask me, how do you want to take title? And I would just kind of play dumb, say, I don't know, what do you suggest? Oh, just take as joint tenancy. And I said, okay. I knew that was the wrong answer, but I just did it to kind of see how it actually happens out there in the marketplace, because I see this all the time. And joint tenancy basically is property owned by 2 or more people. They typically take title at the same exact time. There's a unity of title, time, and ownership and possession all at the same time. Typically, you'll see, let's see, brother and sister as joint tenants, or mom and son as joint tenants. And what that means is that first subtitle there is it has a right of survivorship. Now, what that means is that both individuals, I'm going to go over here and use one of my examples I have here. Here's a piece of real estate. If you guys on the camera can see this, it's a house. And if you have the property taken in joint tenancy, it's the property that's owned at the same time by 2 or more people. Now, in this case with 2 people, they own and enjoy the asset 100%. They both have 100% ownership on it. Now, they may split the income 50-50. They may split the expenses 50-50, but they each have 100% use, enjoyment, and right of possession as part of joint tenancy. And so therefore, when one joint tenant dies, I'm crossing over now to my estate planning land, when one joint tenant dies, we simply file an affidavit of death of joint tenant, and now the deceased joint tenant now's name is off title, and then the surviving joint title winds up owning the property 100%. And from an estate planning point of view, you can see that the deceased co-owner's estate gets nothing. They lost it. The title vested 100% in the name of the surviving joint owner. Why? Because they always owned 100%. All that we did is get the dead guy off title. So here you have a problem with estate planning. So here you actually had a transfer of title from an estate planning perspective. Now, from an asset protection perspective, now, as I just mentioned to you, you have 2 or more people who own the property 100%, which means that either co-owners' creditors can also make a claim on that property 100%. So in other words, if one co-owner has a problem with their kid, with their spouse, their car accident, and you are in a joint tenancy with them, their creditors could come and take that property 100%. So that's a problem with joint tenancy. Now, a little bit different.
Brad,
yes.
Quick question. Does joint tenancy cover spouses also?
Yes, they also have it with spouses. Now, I was just getting down to, in community property states like here in California, and there are about 13 or so. I think it's Washington, Oregon, California, Idaho, Nevada, Arizona, Texas, New Mexico, Louisiana, and I think like Wisconsin. I'm not sure how Wisconsin got in there, but they got in there somehow as a community property state. Typically in community property states, when you see husband and wife as joint tenants, it typically will be interpreted as community property, because it's an asset that was acquired during the course of marriage, and then the family code kind of kicks in and will automatically deem that to be a community asset. But if you look at that third bullet point, in community property states, at least here in California, we have community property with right of survivorship. So you do have a survivorship issue, but that you kind of want. We're not worried about it going off to your brother or sister or your parent. It goes to your spouse, and for most people, that's what they intend. But in other states, all the other common law states, other than the 13 that I just mentioned, joint tenancy is pretty much the primary means of taking title among husband and wives, among spouses. Which also kind of brings me to point number 2, which is tenancy by the entirety. Now, we do not enjoy this in California, but there are about 25 states, about half the states, typically on the East Coast, and moving about centrally into the country. I mean, about 25 states or so that do enjoy tenancy by the entirety. And what that basically means, think of it as joint tenancy plus marriage. Here, you have to have the state allowing for joint tenancy by the entirety, and It only applies to husband and wives in this case. Now, why this is a great way of holding title for husband and wives is because it's designed to protect an innocent spouse, meaning that the pedigree of tenancy by the entirety is that there was a working spouse and there was a stay-at-home spouse. And to protect the stay-at-home spouse from the wheeling and dealing and hustling of the working spouse, that if there's a liability to the working spouse, they don't want the innocent spouse, the stay-at-home spouse, to lose their homestead. And as a result, the states created a form of title called tenancy by the entirety, meaning that the creditor of one spouse cannot force a foreclosure because you have an innocent spouse to protect. So it only applies to married couples with an innocent spouse, meaning that if the two of you sign on for a liability, you both sign on to the credit card, you both sign on to the guarantee, then T by E doesn't help because there's no innocent spouse. But it's actually a very, very powerful tool for a lot of our clients that happen to be in those 25 states that enjoy tenancy by the entirety. Now, for those of us in community property land, I want to point out to you that, and I'm here in Orange County, California myself, and community property, which my wife constantly reminds me, means that all assets acquired during marriage are 50% her assets, and the other 50%, which is supposed to be mine, is also my wife's 50%. That's kind of what she always, so my 50% is hers and her 50% is hers. That's what she tells me. But effectively what it means is that all assets acquired during marriage are community assets, meaning it's 50-50 management and control. But what a lot of people forget, they all know about the asset side of the financial statement, but what's on the other side of the financial statement? You have an asset column and you have a liability column. And so not only are all assets acquired during marriage community assets, meaning that both spouses are jointly and severally liable for the assets, all liabilities incurred during marriage are community liabilities, meaning that the liabilities incurred by one spouse automatically are the liabilities of the other spouse in the community property state, and as a result, all of the community property assets can be at risk. So I'll give you a perfect example of this. So about last year, my wife was on the 22 freeway and she got into an accident. Thank God everybody was just fine. But that was a liability that was incurred during the course of marriage. Now, had my wife been found liable, that would be a community liability. It was a liability incurred during the course of marriage. So had my wife gotten this community liability, I'm here at the office, I'm working, I had nothing to do with this, and now all of a sudden I now have a community liability that's going to come after my community property assets. And what's my community property asset? Well, of course, it's going to be my house. So now I may lose my house because of what my wife did. So in the business world, we would never enter into a general partnership. We would never want to be liable for the acts of our other business partners. So we never enter into a general partnership. We normally enter into a limited partnership or an LLC, because we don't want to be jointly and severally liable for the liabilities of our co-owners. But in the community property state, we are jointly and severally liable for the liabilities of our spouses. So community property is terrible from a asset protection perspective. So it not only does it apply to your assets, it applies to your houses, it applies to your business partners. They wind up having a liability, which then adversely affects your business. So community property is a bad way of holding title, even among spouses here in community property states. Tenants in common, unlike joint tenancy, which is up above, is actually ownership where you actually have a divisible interest. So you can have a disproportionate, so you can have a 60-40, you can have a 70-30, you can have a 90-10. It doesn't have to be equal like joint tenancy, but you also have a divisible interest. There's no right of survivorship, meaning that if somebody owns a 40% in a tenant in common, that 40% can be inherited by their children, or they can devise it to their brother or sister. So that's a divisible interest, unlike that right of survivorship, which automatically vests in the other joint owners. But that also presents a liability, right? because you're responsible here again for all the other co-owners on the property. And then here in California, we signed what's called a transfer on death deed that was effective on 1/1/06 and has a natural termination date unless it gets renewed as to 1/1/21. I use that very, very rarely in an estate planning setting. And one more thing I want to tell you also is how people hold property in their trust, and I get this also. So people say, well, my property is inside my trust. It's not in joint tenancy. It's not in community property. It's not in tenant in common. It's in my trust. Isn't it protected? It's in my trust. And the answer is no. Revocable living trusts offer no asset protection. This includes your rental properties as well. And the reason for that is it's very simple. If you look at who the parties are that create a living trust, you have the trust maker, and I'll just use a husband and wife in this example. Husband and wife are the trust makers. Husband and wife are the trustees. They own the trust assets. Husband and wife are the lifetime beneficiaries of their trust, meaning they can go to the ATM machine and take out their own money. Husband and wife retain the power to revoke and modify. It's why they're called revocable living trusts. Husband and wife have the power to change beneficiaries. Husband and wife have the power to put assets in the trust. Husband and wife have the power to take assets out of the trust. So that exercise should demonstrate that you own so much dominion and control over those trust assets that it is not a separate legal entity from you. Therefore, they sue you, they get your trust. They sue your trust, they get you. A living trust is not an asset protection tool. And I try to put a cherry on top of this one by saying, if I do this by reverse implication, if a trust was an asset protection tool, then why would anybody spend $800 minimum for the California franchise tax to form an LLC? Why would anybody form a corporation? Just operate as a sole proprietor out of your trust. And so you can realize now that it's not an asset protection tool. You still need LLCs for limited liability. You still need corporations for limited liability. And those assets go inside your trust as well as your other assets. So just an important takeaway is that a revocable living trust offers you no asset protection. Now, there are types of trusts that do offer protection okay, another seminar, right? But just remember that your normal everyday estate planning is not an asset protection tool. Okay, so let me go ahead and answer that question. Isn't insurance just enough? Because this is also one of the big pushbacks that we get. And you can see here liability, the insurances come in all kinds of different shapes and sizes. You have auto, umbrella, commercial liability, EPLI, malpractice, E&O, and D&O. So what happens here is that the insurance policies are there, but insurance policies are, I call, limited in time and scope, meaning they have temporal and spatial limitations. And the insurance companies are actually very good at reminding you of this. If you've ever made a claim on your insurance policy, typically the first letter you get back is, Dear Mr. and Mrs. So-and-so, so sorry to hear about your fill in the blank, but I want to remind you of what's called the reservation of rights, what basically the limitations and exclusions are of the policy. So they're limited in time and space, meaning that they're limited in time, meaning only so long as that policy is in force are you covered, meaning that you don't want to miss a payment, and only to the extent that they have accepted liabilities. In other words, there's not an exclusion. And so I normally ask my clients who say that I have a liability insurance policy, I normally ask them the question, have you seen it? I don't ask them if they read it, because I know the answer to that question is going to be no. I ask them if they've seen it. And I always say, is it fair to say that these policies are about 30 to 40 pages, typically double-sided, dual column, 6-point font, and then we go through the exercise of, in page 1, paragraph 1 says you're covered for the following items, and then the remaining 30 some odd pages are all the things that you're not covered for. These are called exclusions. And so what I worry about when people say to me, Brad, I don't need any kind of asset protection for my rental property, I'll just get a larger insurance policy. Well, I don't care how large the insurance policy is. If you have an exclusion in there, It's excluded. That's what it means. It means it's excluded. So there's someone has a meth lab and there's a fire, or you have a dangerous dog that goes off and bites somebody, or they have old out of code wiring or lead paint in there. It's excluded, man, means it's excluded. You're not covered. So that's one thing. You have to worry about exclusions on there. And then the second thing we have to worry about with insurance policies are insufficiencies of coverages. And this is a case I dealt with a handful of years ago where there was a fire on the policy, on the property, and there resulted in 3 people dying. And then there was a wrongful death against my client. And then the insurance policy was for $3 million. They had the underlying policy and then a couple $1 million of an umbrella policy. So here we had $3 million of coverage. Problem was we had a $12 million wrongful death claim. So they had the policy. The policy said, yep, we're going to cover you 100% policy limits, $3 million. Problem is you now have a $9 million deficiency, and the client coincidentally was worth about $8.5 million. So here, again, it's good so long as it's covered, and 2, as long as you have enough coverage and or the adjuster doesn't come down and adjust it for some reason they only adjust in one direction, and to make sure it's a covered event. So that's kind of my response to people just say buy more liability insurance. You have to worry about exclusions, insufficiencies of coverages, insurance adjusters, et cetera, whereas once you have asset protection tools, you're not limited in time and scope. There's no timestamp of when they received the payment. As long as your entity is in good standing, it's there for your lifetime and for future generations if you want to pass that property to your successors via your estate plan. That same LLC, that same trust will even survive you. And it doesn't just cover whatever's listed on those 35, 39 pages. It covers everything, right? Everything that's within that tool. If it's an LLC, it covers everything in that LLC. So you're not limited in time and space. So it kind of covers, so when those insurance policies fail, rather than you owning those liabilities, you now further contain that liability inside a limited liability tool, whether it's a trust or some form of entity. And so it's typically your second line of defense. So insurance is always an important element of an asset protection plan, but it's not a plan in itself. And if you remember back to my initial statement, I said asset protection is about leverage to get you out with a fast and favorable settlement. And what's that settlement? Policy limits. Take the insurance because the other assets are more difficult to get, and it's easier for you to take the insurance and settle out. But you gotta have the insurance policy. It's not a replacement for it, it's a supplement to. All right, so make sure that point is clear, because I'm not talking about not having insurance. This is a supplement to your insurance policies. But just don't be overly reliant on the insurance companies. Okay, so now let's talk about LLCs. LLCs are the primary tool that we use modernly to hold real estate. There are some folks that still have properties inside corporations, which in our opinion is the wrong way of holding title, because it has some adverse tax consequences if you want to move properties around. Limited partnerships were very popular for many decades, but since about the mid-90s, LLCs really have been the main tool that people use to hold real estate. So what is an LLC? This is just a diagram description. So you'll see here that the LLC, in my example here on the screen, is everything inside this green oval. And inside the green oval, we have a couple of pieces of property. We got little property and big property. Call it a condo, call it a commercial building. The person managing the assets of the LLC is called the LLC manager. You could think of this person as, from a corporate analogy, think of this person as the director, the brains, or an officer, a president, a CEO, someone who actually has the power to do stuff inside the entity. That's called the LLC manager. Now, the owner of the LLC is called a member. So similar to a corporation, they would be called the shareholder, they would be called the stockholder, but it's the member. We don't want to confuse our corporate lingo with our LLC lingo, so you have members and managers, not board of directors, officers, and shareholders. So we say that LLCs have internal protection, meaning that if our condo, we have a slip and fall, and as a result, they were able to capitalize on that that property because the slip and fall is happening inside the oval. You'll see me on quotes here say internal protection, meaning that someone slips and falls in the LLC, they can gobble up all the assets inside the LLC. So the first asset they go after is the property in question. They slipped and fall on the condo, they go after the condo. But if the condo wasn't sufficient, maybe because it was encumbered, maybe it was only a couple $100,000, they can then go after every other asset inside that oval. I call it the Tasmanian devil. They just kind of zip around, wow, 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 until they gobble up all the assets. But it will give you personal liability, and that's the main point. This is a limited liability tool. So you may have lost all the assets, but you have limited liability to you, no personal liability. So when I go around and I talk and people say, well, Brad, I don't need any additional asset protection. I have all my assets inside an LLC. I say, great, tell me what's inside there. Well, I got my condo, I got 4 apartment buildings, I have a couple of duplexes, I have a commercial building, all inside one LLC. And I say, great. What else is in there? All of my tenants, all the contractors I have working on the property, any other obligations I may have. And so what happens here, there's no internal diversification, and not all properties are created equally. And we as landlords know that some properties have what I call higher risk profiles. You know, you have single family homes versus duplexes, triplexes, fourplexes, apartment buildings. You got more souls on the property, and the more souls on the property, the more likelihood you're going to have a liability. It's simply the law of large numbers. And the properties themselves may be different. They may be nice gated communities. It may be slumlord stuff. It may be good neighborhoods. It may be bad lighting. Maybe whatever, low income, high income, college kids doing what college kids do. You have different characters. You got residential versus commercial. Activities on commercial property with forklifts and drivers and trucks. Very different than mom and dad coming back from work at 5 o'clock in the afternoon. Different risk profiles. But if you mix them all into one bag, you've put every asset at equal footing. Your lowest highest risk property will affect your lowest risk property, because they don't sue the property. They sue the owner of the property. So back in this example here, the condo plaintiff doesn't sue condo, the residents. They sue Condo Holdings LLC. And so every single asset inside Condo Holdings LLC is at risk. So it's not a matter of bundling. You got too many eggs in one basket. You want to diversify that. Yes, it gives you personal liability, but you've also lost all of your assets. So with any kind of asset protection structuring, one thing that we look at is how do we create multi-entities, building liability firewalls between assets, segregate individual assets from individual entities. Very simply, don't put eggs in one basket. And so here, back to the exact same example, LLC 1 condo had the exact same liability, but now that liability is contained. They can't get over to LLC 2 because it's not LLC 2's liability, it's LLC 1's liability. And even if you completely consume and foreclose on all the assets and have a deficiency, it stays inside LLC 1. They can't get to LLC 2 and they can't get to you. That's the magic of having a multi-entity structuring strategy. All right, so it's a matter of don't put your eggs in one basket, and then we break them apart, because especially even here in California, it's also very expensive. You have a minimum franchise tax of $800. Then on top of that, we may file you in different jurisdictions. You have to worry about gross receipts. If you have gross receipts of more than $250,000 per year, which is very likely on a commercial level, maybe not so likely on an individual residential level. But if you have a whole bunch of apartments built into one LLC, you may have gross receipts problems. So we have to take a look at in the analysis and find out what's the right mix, liability mix, asset mix, equity mix income mix to find out what the proper use of the LLC is, because it's expensive here in California. You're not going to get around it. And so one question that commonly comes up for me is, hey, Brad, what if I form my LLC like in Wyoming or something? Do I have to register it in California? And the answer is yes. But what if, wait a second, what if I have the property, in Nevada, and I have a Wyoming LLC and my property manager's in Florida? The answer is yes, you have to register it here in California. The FTB takes a very aggressive stance that if you're the manager, remember the manager, let me go back over here, you're the manager, you're the one making the decisions regarding that entity. The FTB says if you as manager breathe California air, and if you have the power even to hire and fire the property manager out in Florida, then that entity is doing business here in California. So you can't just set up a Delaware LLC or a Wyoming LLC or an Arizona LLC. If you are in California, it's doing business in California. And certainly if it owns California dirt, if either one of these properties is California dirt, by definition, it's doing business here in California. So don't just think that getting creative by trying to use different jurisdictions automatically gets you out from under the California, oppressive $800 a year. It's just one of the things that we have to deal with. So we try to maximize our dollars by using wisely, coming up with some system for our multiple LLC strategies. So hopefully that addresses a question that comes up quite often about the California minimum for franchise tax. You got to still file in California if you're here or if the property is here. All right.
Brad, real
Yes.
quick,
Yep.
someone asked here, what defines a manager if an owner is a member?
Okay, so there are two different types of LLCs. You have what are called member managed and manager managed. So member managed it just means that the members, that is the owners, the members, are also the managers. They're also the brains. And the percent vote that they have at the management level is the same as their ownership level, because it's member managed. You're a member, you're in at your percent vote. Think of it kind of like as a stock, right? It's just you have a stock, however many units of stock you have, that's how much you get the vote, right? Very similar. Now, in a manager managed LLC, the manager can be a third party. The manager can be you, or it can be somebody else. So my sister and I can go into a business together to buy a piece of property, and my sister's Amy. So Brad and Amy can be the members, the owners. If I say, hey, Amy, listen, I'm a lawyer. I do this for a living. Let me be the manager. I have the whole back office of the law firm. Let me manage the property. My sister says, fine, no problem, you do it. So this would be, Brad would be the sole manager, but Amy and Brad would be the co-members, right? Because there's difference. Whereas if my sister and I went into a member managed LLC, it'd be Brad and Amy 50-50 as members and Brad and Amy 50-50 as managers. So we very, very often create manager managed because it allows us to move membership around without giving up our client's control as the manager, right? And so it's also very easy to convert that. There's a Secretary of State form here in California where you can simply amend your articles of organization to go from a member managed to a manager managed. And then you just got to follow that up with some modifications to your operating agreement so you have the appropriate powers, et cetera, et cetera. But that's our particular preference. And I hope that answers the question. Okay, just kind of moving on. Here now we talked about the internal protections. Let me kind of this to recap. So this is the internal protection. You see we had liability number 1, protects asset number 2, and also protects you. That's an internal liability. But LLCs also have what I call dual protection. You'll see that one in quotes here. And dual protection means that, well, not only do we have the internal liabilities, but what if we get into that car accident? I gave you the example of my wife. My wife, God forbid, gets into a car accident, and now I have a liability. Well, if I'm found liable, and I have to go to that debtor's examination and list all of my assets in the collection phase, What are the assets I have to list? I have to list my LLCs. And so now my creditor, my judgment creditor, is going to come after my LLCs and try to grab my LLCs, because the LLCs are my assets. My house is my asset, my brokerage account's my asset, my retirement's my asset, oh, and my LLCs are my assets. So we want to make sure your LLCs are set up properly to protect the assets from you. We're not worried now about the tenant being the source of liability. We're worried about you being the source of liability to your assets. And maybe not you, your business partner, your business partner's kid, your business partner's spouse, your business partner's dog. They get a liability. You don't want their creditors going up and grabbing your assets, right? Bummer. So LLCs, unlike other forms of entities, give you dual protection. They protect you from the internal perspective, and set up properly, they give you what I call external liability protection too. Very, very important benefit. And what our clients do is to protect their assets. This is asset protection, whereas this is liability risk management. Here we're worried about the internal liabilities, and here we're worried about the external liabilities. And thankfully, it's the same tool. Just a very well drafted, properly set up LLC will give you both limited liability and asset protection. So as a result, we then set up our LLCs in different states that have more preferable laws. So here's an example: Apartment Holdings, Delaware, authorized in California because the dirt's in California. Townhouse Holdings, Nevada, authorized in California because the dirt's in California. So we're using these preferred jurisdictions. They're still registered in California because here we're trying to maximize both our limiting our liability and maximizing our asset protection. All right, so let me kind of just go over now to our residences. And again, I'm going to talk a little bit more specifically about California when it comes to homesteads. Now, what a homestead is, it's an exemption. Every state has what are called exempt assets. And exempt assets are exactly what they say. They're exempt assets, meaning that a creditor cannot grab them. Many people are familiar with bankruptcy exemptions. They also apply for creditor exemptions. And the public policy behind it is that if you have a liability and a creditor comes in and takes all of your assets, and you don't have two nickels to rub together, whose problem do you become? Well, you become the problem of the state. Right? And a ward of the state. Well, the state doesn't want that. They want you to have enough assets to be able to get a fresh start. And every state is different as to what assets they deem sufficient to get a fresh start. And all of us are familiar with the O.J. Simpson scenario. Happened about, what, 25 years ago, just last week, I think it was. And if you recall, he was found liable for wrongful death, but he didn't lose his home in Florida, his multi-million-dollar property in Florida. He didn't lose his NFL pension, even though he was found liable for wrongful death, because those were exempt assets, exempt in Florida, Homestead, and then the pension was exempt under ERISA law. So exemptions are very powerful, and every state is different. So in Florida, you have an unlimited exemption. Texas, anything you can build on 2 acres of land. I think Nevada is $550,000 of equity. California, if you're single, you get to keep $75,000 of equity, or if you're married, $100,000 of equity. I believe if you're 65 or have a disabled dependent inside, you get to keep $175,000 of equity. So I always tell a little joke that, I live here in Orange County, and I say my house, my bedroom closet, especially with all of my wife's shoes in it, itself is worth more than $100,000, right? So we have some of the most expensive property in the country, yet we have some of the lowest homestead exemptions, which means that if a creditor wants to take my $1 million property away from me, and I have $400,000, $500,000, $600,000 of equity in it, the creditor is only obligated to give me $100,000. That's it. That's the California homestead exemption. And the other $300,000, $400,000, $500,000, $600,000 is taken away from me and used to pay for my creditors. And I'm on the curb now, burping and chirping with no property. My kids are out of the community. I have no house, and it's a bad deal. So we don't like that. We try to find ways to protect our clients' houses. Here again, a house is different than a rental property. We don't just throw it into an LLC. We have to use a different tool. Another tool that we use is equity stripping. So one thing that we do is, well, what if we were able to suck all the equity out? We call it equity stripping out of the property, because if I get into a car accident, the creditor really doesn't want my house. What they want is the value that the dirt represents. They want to have a judicial foreclosure. They want to get the money out of it and use it to pay the creditor. They don't really want my home. So if my home has no equity in it, my home is not as attractive. So for example, the example I just gave, house is worth $1 million. I have a mortgage of $400,000. That gives me $600,000 of equity. I have a California homestead of $100,000. That means the available equity is $500,000. Okay, great. But what if I get a second, and I get a second for, I don't know, $400,000, or I borrow money from the law firm, or I borrow money from my parents, and my parents put a lien on my property. They put a second on my property for $400,000. So bank is in first position for $500,000. Mom and dad or company lender is now in second position, recorded for $400,000. I have a California homestead exemption of $100,000. Right now I have $1 million of assets, and I have $1 million of encumbrances. Now my house has a value of 0 to a creditor, because if they sue me and they foreclose on it, they have to get in line. They have to pay back the first, they have to pay back the second, and I get my homestead exemption. So here we're able to take a very attractive asset and make it unattractive by use of debt. Now we need to put that equity somewhere. That's seminar number 2 on other versions of asset protection. But the point I want you to take away is that our properties are very, very public. The most public thing you want to find is public records recording your properties, rental properties, residentials, etc. You want to suck the equity out and make it encumbered as much as possible, because there aren't many tools available to protect it. So equity stripping is one excellent tool, again, making it to a very unattractive. So one of the things I get, well, Brad, you just got done telling me how wonderful these LLC things are. I get limited liability, I get asset protection in these multiple jurisdictions. Well, I just shove my house and put it inside an LLC. This is what I was telling you earlier about changing the characterization. You changing your character of the dirt from residential dirt to investment dirt by putting it inside an LLC. And as a result, you lose some of those tax benefits that's associated with residential property and not commercial property or investment property. And that one is a $250,000 capital gain exclusion per person on sale. That's for residences, not investment property. So that could be up to $500,000 of capital gain exclusion on sale of property for a married couple. You may lose some of your interest deductions, because again, that's an encouragement to get a mortgage to buy property. We'll help you write some of these things off. Solar panel benefits, property tax. I mean, we are capped at $10,000 a year here under the new current law. But the point is, you lose some of those benefits when you transfer, when you transition your property from residential to investment property. And then you would lose the homestead exemption, because here, although it's not that great of a homestead, it's reserved to residential property, not investment property. I'm going to skip this tenancy by the entirety, because I think we've already spoke about this a little bit. And so one of the options that we use, so we've already talked about the use of debt. Debt is a very powerful asset protection tool. And the next thing that we use, what I call residential privacy shield trust, or residential privacy holding trusts. And so this is where we don't put the property itself in an LLC. You put what's called a beneficial interest into an LLC. And I know it's a little bit more complicated. I have a whole different 15 or 20 minute instructional video for my clients on how this thing operates. But what this does both privacy as well as asset protection. And what you can see in on the left-hand side of the screen is that the property itself is put inside a land trust, LAND trust, not a revocable living trust for estate planning purposes. This is a very unique type of trust called a land trust. And as a result, we also can get you off public records, or our clients go incognito. We do this a lot for celebrity clients. We do it for sports figures. We do it for business owners. Property owners are great for this, because the last thing you want is your tenant knocking on your front door at 3 o'clock in the morning complaining about the toilets. So we don't want the tenants to know where you live. And it's very easy to find where you live based upon public records. So we want our clients to go incognito. I myself, as a lawyer, as a professional trustee, I don't want beneficiaries strung out on drugs, whatever, coming to my house saying, give me some more money, trustee. So this is what I have for my home. I'm off the public records. I'm incognito. So I first get off the public records by putting it inside a land trust set up properly. And then we take that trust, that what's called the beneficial interest, and we put that inside an LLC. So unlike what we did with the commercial properties, where we put the dirt in the LLC, here we put the beneficial interest of a trust inside an LLC. So we don't put the dirt in the LLC, we put all the powers to control the dirt inside the LLC. So think of it as a stock certificate. The stock certificate owns the company. The company owns the property. Whoever owns the stock certificate can cause a liquidation of the corporation and thereby liquidate the real estate. Well, by analogy, that's what a land trust does. We turn your dirt into a stock certificate. So we don't protect the dirt, we protect the stock certificate, the beneficial interest certificate. If the creditor can't get the beneficial interest, they can't get to the dirt. It's 1 degree separated. It's like I said, we use a conduit entity called a land trust to create this residential privacy holdings trust. Does not trigger due on sale clauses with banks, does not trigger Prop 13 reassessment issues. It gets you off of public records. For those of us that have HOAs that are very aggressive, it doesn't offend them as either. It's a very, very good way of taking care of our property, and it still stays classified as residence, which also is important for that Prop, I think it's Prop 90, for parent-child exclusions for property taxes for our kids. So very, very important, because Prop 13, from an estate planning perspective, when you transfer your home from a parent to a child, you have an unlimited exemption on Prop 13 value. So it's very important. We want to keep that. If you take your residence and put it inside an LLC, there's no such thing as a LLC to child Prop 13 exemption. When your kids inherit that through your trust, they're going to be reassessed at the present day of death value. And that's a big ouch. So we want to preserve that Prop 13 basis, that unlimited exemption on residences, by using this structure as well. So we also cross over here again from an estate planning perspective. Another option is a more advanced tool called a qualified personal residence trust. I mentioned here on top, option 1, land trust, no tax benefits. For our clients that do have estate taxes, and even under the current very favorable Donald Trump estate tax laws at $22 million for a married couple or $11 million per person, even here in California, our business owners and large landowners still have tax issues, estate tax issues. And so we use this quite often as, one, an estate planning tool to minimize your estate taxes, as well as a very effective asset protection tool. Okay, residence trusts. So we're going to go ahead and just put, in conclusion, just kind of want to wrap up and understand that, again, I'll just reiterate once again that investing in real estate is an excellent investment, and thankfully we have a very wealthy client base, and almost every one of my clients has some form of real estate tied into their portfolio, whether it's rental properties or owner-occupied buildings for the businesses. And just understand that it's a great tool, it's a great asset, but it just comes loaded with a potential liability. So therefore, just acknowledge it and just address it, because that same legal system that gives the tenants, the plaintiffs, that come after you, to steal your wealth from you, is the exact same legal system that put tools in place to protect you, to limit your liability from these grabbers. So the idea is this: do these things before you need it. There's just a smart way to go about holding property. So with that, I know I'm right about at my time here. I'll hand it back over to the moderator, and I think she'll request that you ask a question or two. I'm more than willing to stay on for another 15 minutes or so, as well as to complete that consultation request form.
Yes, thank you so much for that. I'm going to launch the first poll question here, just to ask who on the call still would like to take advantage of the consultation. Hold on just a moment. All right, it's on your screen. In the meantime, while you are answering that question, I'm going to start with a few of the questions that we've gotten so far. First one here from Kenneth. He's been told that his property can't be put into an LLC because it's backed by a government FHA loan. Is that the case? Okay, great. So when it comes to any type of lender, understand, and this is, and whether it's a federal lender or a private bank, what's being referred to here is the due on sale clause. And the due on sale clause is a protection for the bank to not transfer their collateral away to some third party. So it's a protection for the bank. Now, most banks are very sophisticated, and they understand that if you have the property taken in the name of husband and wife, and then husband and wife then create an LLC that's owned 50-50 husband and wife. So it's 50-50 before husband and wife individually. They create an LLC that's owned husband and wife 50-50. And they take the property and go out of their name and put it into an LLC that they own 50-50. So what's happened in this transaction is that there's no new owner. It's 50-50 before, it's 50-50 after. I say it's apples to apples. And what you've done is you've changed the form of how you hold title, but there's no new owner. And most banks, and I'm talking over 22 years, I've transferred thousands of pieces of property over the decades, and I can tell you that very, very small amounts have been resulted in due on sale clauses. And so what they're saying here is that as long as the ownership is the same, you haven't then given the property to third parties, it won't trigger a due on sale clause. Now, I can't say it won't, but typically it doesn't result in a due on sale clause. It's when you go from husband and wife 50-50 to husband and wife 80 and son 420. Okay, now you have a new owner. Now the bank didn't underwrite your son as a risk. Now you gave 20% of the bank's collateral away to your son. Now the bank gets worried. Now they exercise due on sale clauses. That's a problem, right? So typically, as long as you're going back and forth, apples to apples, banks don't get offended by that. They know what's going on. Sometimes if the client is worried about it, we can always get the bank's blessing before we do anything like that. They may want a legal opinion on it, no problem. They may want another guarantee, make the LLC itself an additional guarantor, no problem, because it's not the bank we're trying to protect ourselves from. We brought them into our life. We're worried about third parties and protecting us individually. So there are multiple ways of dealing with this, but I can just tell you over 2 decades of practice, in less than 5 times has this ever come up, and it's only come up in a commercial setting, and the resolution was a legal opinion and maybe a couple $100 for the bank to put the LLC on as an additional obligor on the loan. So it's the least of I think of most of my clients' worries. But it is a good question. Great. And from Peter, does the manager in an LLC, is the manager of an LLC liable?
Yes, yeah. So you have same type of officers and officers and directors liabilities. Managers can be liable. So because remember, they're responsible for what's happening inside the LLC. So if they're purposefully keeping a slumlord property and purposefully not cleaning up and taking care of the electricity, whatever, yeah, they're going to be liable for that on a personal from the manager's perspective, right? So
okay,
yeah, because it says it's professional negligence from a manager's point of view, right?
Okay, and I have one more question so far, just to clarify. in transferring from a residential property to an LLC,
Yep.
would it be a good idea to take advantage of some of the benefits, like the solar panel or whatever benefit, before you do that? Or how can you do it in a way to still preserve some of the benefits?
Right. So the whole idea here is you just want to make sure that the property never changes its characterization from residential to investment. That's all. And so long as that's the case, and so that's why we like to use that residential privacy shield trust, because we do maintain that residential classification, then all the tax benefits are still available. So if you wanted to do solar panels before you make the transfer, great. If you want to take advantage of that tool and then do solar panel, no problem, because it's still classified for tax purposes as what's called a grantor trust, or classified as a residence. So even though you're doing all this through this trust, you're still able to take advantage of all those tax benefits, solar panels, etc. That's why it needs to be done properly.
Got it. And just following up on the previous question from Peter, he said many LLCs have only a managing member. So if that's the case, how is the owner protected if he's the only managing member?
Yeah, well, that's where also what I was telling you about changing it to member managed to a manager managed, and then there's nothing stops you from getting like a director's or officer's insurance policy. Oh, my light just turned off. 1 second here. Okay, I'm getting an insurance policy on that, and so you could use the income coming off of the property, again, as a ordinary and necessary expense and further deduction on the income there, to purchase a professional liability policy. So not only a liability policy for activities on the land, but if you're worried about that, there should be a liability policy to protect the manager from their professional acts, right?
Okay, and last question here from Tina. If LLC is GP on LPRE entity, is husband and wife would both be liable as a manager? I'm not sure if I'm understanding the question. Do you understand what I'm saying?
I think she's saying is if you have an LLC who's acting as the general partner of a limited partnership. I think that's what she was saying.
Okay, got it.
That's the right way to do it. First of all, that was right, so good for you. Okay, because inside a general partner limited partnership arrangement, the general partner has unlimited liability for the acts of the underlying limited partnership. So if here again you want to put a wrapper around that general partnership interest to insulate you personally from the liabilities of the partnership enterprise. That's also where you would have that same type. So first of all, you've limited your liability as the general partner. You also want to protect that general partnership interest from your creditors. And then, just like in the previous example, previous question, you also should have a manager's E&O policy, because you are responsible for the acts as the general partner for the underlying limited partnership. So if you're worried about liabilities coming up for your professional decisions, then yeah, you should have that internal liability policy. It's a good idea. It's always a good idea to have any type of professional insurance.
And from Tina as well, does this provide the asset protection still on the joint personal assets?
Yep, that's right. Yep. Mm-hmm.
Perfect.
Yep.
And from Joyce, if I hold my rentals in an individual revocable trust, would my husband be liable if sued?
Okay, one more time. I didn't get the first part of that.
If I have my rentals in an individual revocable trust.
If I have my what in a?
Rentals.
Rental, okay, gotcha, right.
Mm-hmm. In an individual revocable trust, would my husband be liable if sued?
Yes. Next question.
Okay. Yeah. From Agus, I have fourplexes in Houston, Texas. Can you manage and handle structure of Superiors LLC for Texas property?
Okay, I'm sorry, you broke up there. One more time.
Agus says, I have fourplexes in Houston, Texas.
Right.
Can you manage and handle the structure of Series LLC for Texas properties.
Series LLCs, I think he's asking about. Is that right?
Yeah, he spelled it S-E-R-I-E-R-S.
Yeah, series. Sorry. So series LLCs. Now we here in California, we don't do series LLCs because there really is no difference between a series LLC and having multiple LLCs. Those are more creations of other states' law, specifically Delaware, and mostly designed to hold like hedge funds and financial tools. I am aware that clients do put properties inside various cells of a series LLC. I myself, we don't do that, and so I'm hesitant to offer any advice in that direction. But if the state law recognizes series LLCs and each property is inside its own cell, then it should function just as I showed before, as far as having multiple LLCs, not putting all your eggs in one basket. That's the general idea. Because we don't do them here in California, I just don't know exactly how the other states would interpret that. But that's the idea. Each cell represents its own separate entity under one master series LLC operating agreement. But that's the idea.
Okay. From Tom, I manage my parents' apartment complex in Arizona, which they purchased in the Revocable Living Trust. If I set up an LLC, would I put the property within the LLC and add the LLC as an asset of my parents' living trust?
That's right. That's exactly right. That's right. So the property, if you guys can still see me on screen here, what we do here is you take this is an LLC, this is just a glass, and then here's your property, right? So you put the property inside the LLC, and then that LLC then sits inside mom and dad's trust. So that's why I use those Russian dolls as a very good example. So right now, if mom and dad own it individually and you're just kind of managing it for them, mom and dad would create that managed LLC. Mom and dad would have the apples to apples, mom and dad are the members, put it inside here, and now you are the manager. But the ownership of this LLC now goes inside mom and dad's trust. And you can still manage it, no problem. But now it's asset protected, you're protected from a manager's perspective, mom and dad's estate's protected, and it's designed in a probate avoidance and a legacy transition tool, the estate plan. That's the proper way it should be done.
Okay, and he asked us a follow-up, can I use the LLC as a way to transfer ownership from my parents to me eventually or now? That's my parents' goal.
Yeah, absolutely. We use LLCs as gifting tools all the time. It creates what are called fractionalized discounts. And for those of you that are CPAs in the audience would understand what that is, to help minimize estate taxes. But one thing I would caution is that there's a very big difference between, especially in family members, there's a very big difference between having mom and dad gifting you assets as opposed to inheriting assets. It all has to do with what's called the step up in tax basis. And so as harsh as this may sound, I'd rather mom and dad die owning it and I inherit the property as opposed to mom giving it to me during lifetime. I'm in a much better tax position to sell the property as an inheritance than I am to sell it as a gift, as a receiver of a gift. And again, that's purely capital gains and tax basis issues. So if there's no immediate need to transfer ownership during lifetime, that is an estate planning or estate tax point of view, I'd rather mom and dad just keep it in trust and then pass it that way. Again, absent doing some other more advanced estate planning that we could do during lifetime. There are various types of tools, but for most people, it's better to inherit than to be a beneficiary of a gift. Unappreciated assets. Yeah.
Okay, so now we're really coming to the last question from Peter, which is, how does a professional liability policy for a manager protect him against creditors in an LLC?
It doesn't. That's nothing to do with it. The creditor is on the inside liability or the outside liability. That's more the creditor attack. When they're coming after you as a negligent manager, they're just making a claim for more liability for behavior that way. But most times when it comes to creditors, we're talking about tenant-based liabilities coming after the property owner, because there is that a duty to make sure the property is habitable, or the creditors coming up from you personally trying to get up inside your LLC to take the assets away from you. So they're just they're different types of creditors. That's all. And like any other insurance policy, if someone's attacking you for your professional malpractice or professional negligence, then the policy will come in and offer you a means to enter into a settlement. Yeah.
Okay, perfect. Yeah. Well,
I guess that's just the
thank you so much. Thank you especially to Brad. We loved it. So really appreciate your time.
No problem. My pleasure. Thank you very much.